Thank you, Mr. Chairman. Mr. Levine, what does it mean for journalists to have qualified privileges?
Well, there are two important words there. One is qualified and one is privilege. The privilege means that, at least presumptively, they will not have to disclose the identity of their confidential sources or unpublished information that they chose for journalistic reasons not to publish in response to compulsory process like a subpoena. The qualified part means that that is not absolute, so that this bill, and I think most reasonable people recognize that there have to be narrowly drawn exceptions to that, like are set forth in this bill with respect to terrorism or imminent threats to national security. And I think one of the geniuses of this bill is that it really does articulate very well those limited exceptions and articulates how limited they are and need to be.
Well, I thank you for that answer, because it led into what I was going to come to next, because a lot of people are going to be concerned about whether or not we go to such great lengths to protect the confidentiality between a journalist and their source, even to the extent that we might not get information to defend us against an attack, or that might compromise national security. But even with the law that we have here, or the bill that we have here, that's not an issue. Would you agree with that?
I do agree with that, and in fact, the exceptions to the application of the privilege, that is the issue, the instances in which the qualified privilege would yield, are taken almost verbatim from the Department of Justice's own guidelines that the Department has itself purported to govern itself by over the last 40, 50 years. The only difference here is that the decisions that the Department's made will now be reviewable by a court instead of being undertaken in their unbridled discretion.
Ms. Atkinson, you've been involved in some major stories, Fast and Furious and Benghazi, and obviously your ability to report on those, conduct your own investigations has been greatly enhanced by being able to protect confidential sources. But in your testimony, you said that your activities were being monitored. Am I correct? Is that how you said that?
Yes.
Okay. Can you elaborate on that? How you were being monitored? Do you believe you were being wiretapped, or that there are other intrusive methods that were being utilized?
According to our forensics reports.
Would you hit the mic, please?
According to our forensics reports, and we have 4 separate independent reports that give similar pieces of the puzzle, there was a long-term effort to monitor my computers and excuse me, phone devices, both my personal computers and my CBS computers.
But how would they monitor that without a warrant?
Well, we don't know that they didn't have a warrant, although I had 2 sources tell me there was no FISA warrant. So the way I'm told that sometimes works is they identify someone in the orbit of the person they want to watch, and then they capture you in incidental surveillance, meaning they pretend that it was sort of an accident. And then they kind of reverse engineer it so that they can actually get the information from the person who is really the target that they didn't think they could get a warrant from. So as we've conducted our investigations forensically, there have been a lot of questions about who I might have contacted in foreign countries, which would create a pretext or a premise to make it look as though someone needed to be watched on that end, which would then sweep up my communications as well.
All right. I just wondered if you had filed a Freedom of Information Act request on that to try to determine the extent of
yes, sir.
Intrusive.
The FBI has repeatedly denied my Freedom of Information Act requests or not fulfilled them properly, claiming they don't have information that they provably do have. And there's, as you may know from your previous FOIA work, very little that can be done about that.
Mr. Bloom, I don't want you to feel left out. Questions from a gentleman from Alabama. So one of the things that I'm looking at are all these states that have basically a patchwork of laws that cover this. And one of the things that I was wondering about is you could be in one state and be covered and be in another state and not be covered. You might be an out-of-state journalist and not be covered by any state law. Can you elaborate on that, please?
Well, I think, as Mr. Levine mentioned, that depending on which court you're fighting the subpoena, you may get a different result. We all start with the First Amendment, but at the current state of affairs, you may be in Alabama and you may be able to successfully fight a request for a murder suspect to want to interview you about the kind of interviews you've done. The problem with that is you're also going to be cross-examined. So a reporter doesn't want to be put in a position of providing all their notes. But it is true that it is very much a patchwork.
I generally am not for extending federal power, but I think when it comes to constitutional issues, and I really think it's an area where the federal government does have a legitimate need to intervene. And again, I want to thank Ranking Member Raskin and Chairman Jordan for their work on this. I think this is important work. And with that, Mr. Chairman, I yield back.
Thank the gentleman. Gentleman from Maryland is recognized.